If you've studied the Constitution for a while, you've probably heard about this thing called judicial review and the Supreme Court case Marbury versus Madison. Now, don't worry, it's not nearly as boring as it sounds, but I will tell you what you've probably heard doesn't exactly match up with history. We'll find out more next on the Constitution Study Live.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here. I'm glad you could join me. We are a day late thanks to some issues with Facebook yesterday, but we're here. I'm glad you could join me. If you're not listening live, at least you follow the recording. We have an interesting topic. First, as always, I want to head you over to the website, constitutionstudy.com. That's where you can find out everything Constitution Study, all that we're working on, and everything new that's coming up as it's going along. I also want to give a special shout out and a thanks to Mark and Carol Murphy and the band Rebel North. They actually wrote the song Everyday Americans that I used in the bump video. So thank you for letting me use that. Also, a little bit of housekeeping before we get started. If you're in the Nashville area, there's a homeschool conference March 28th through 30th. I have a booth. I even have a speaking slot where I'll be talking about the 3 myths about the Constitution. But if you stop by the booth, hey, come say hello. And maybe there'll be a surprise in there for you. Have some fun I'm trying to work up so we'll have a good time. So swing by there. Also on June 8th, I will be in northern Georgia, Clarksville, Georgia, for the Northern Georgia Christian Educators Conference. Stop by. I'll have a booth. I'm not speaking at that, at least not at the moment. But again, if you're in the North Georgia area, stop in, learn about some homeschooling, and stop by the booth and say hello. Maybe we'll have a little bit of fun while you're there. So one of the things I love about studying documents like the Constitution is going back and finding out what really was said and what really was done. And that's going to impact what we have today. I've studied the Constitution for a while, and, I'm sure if you have too, you've heard about Marbury versus Madison and something along the lines of, Marshall established a principle of judicial review, i.e., the power to declare a law unconstitutional. Oyas, they're part of the Cornell Law School, and it's the basic idea that any act of Congress basically can be vetoed by the Supreme Court. Those of you old enough to remember, President George W. Bush signed a part of the Patriot Act, I think, and he said, well, I don't think this is a constitution, but we'll let the courts figure it out. A rather blatant failure of his, shall we say, constitutional duties. But it got me thinking, is that really what Marbury versus Madison said? Because if it did, I was upset, because there's nowhere in the Constitution that the court gets this power. So I did something unique nowadays. I actually dug up the opinion from Marbury versus Madison. I'll have a link in the show notes, and you can read it yourself. I read it. It's a lot of legalese. It's not terribly fun, but it is really interesting. So let me give you a little background, because it'll make a little more sense then. In 1800, President John Adams lost the presidential election to Thomas Jefferson. Now, Adams was a Federalist and Jefferson was an anti-Federalist. Now, contrary to some popular sayings or popular information, the anti-Federalists were not against the Constitution. The Federalists wanted a strong central or federal government. The anti-Federalists wanted a lot of restrictions. They wanted a powerful restraint on that federal government. They were afraid that the government was going to take over. So here we have a real political change. It's kind of like when Donald Trump won the election, and we went from a Democratic president to a Republican president. So John Adams decided with some of his Federalist buddies that they would try and pack the courts. They created, because Article 1 says Congress creates inferior. Actually, no, it's Article 3. Sorry, Article 3 says Congress creates the inferior courts. So they created a bunch of them, and Adams got some good Federalists and nominated them, and they passed the Senate. but their commissions weren't actually delivered. Now, the way this works is once a person's nominated and approved by the Senate, what actually happens is the form, the paperwork gets sent to the Secretary of State. He puts the seal of the United States on it, and he issues a commission to the recipient of the office. Well, that last step didn't happen. So when the Jefferson administration came in, James Madison was the Secretary of State, and guess what he found on his desk or somewhere nearabouts is a stack of commissions that hadn't been delivered. Well, Madison decided no, the Adams administration were playing fast and loose with the rules, so he decided, you know what? I'm not going to deliver the commissions. Now, this, as you can imagine, kind of bothered the people whose commissions they didn't get. So what we ended up with is, let's see, the Adams and Federalists created 16 new circuit courts and 42 new justices of the peace, and William Marbury was one of the guys who didn't get his commission, so he petitioned the Supreme Court to force Madison to give him that commission. Now, the case before the court really broke down to three important points. One, did Mr. Marbury and the other plaintiffs who had joined his suit, did they have the right to receive their commissions? Were they properly done, properly vetted, everything was done? That question number one. Question number two, could the plaintiffs sue to get their commissions? In other words, was it right for them to go to court to get this information, to get these commissions? And then third, did the Supreme Court actually have the authority to order the delivery of the commissions? Those are the three key points before the court. Now, I read through all of this, and the first 2 points were fairly straightforward. They said, yes, these were fully vetted. Everything had been done that had to be done to make these commissions legal. Everything but the delivery. The delivery is not a requirement for it to be a legal office. So, yes, Mr. Marbury and the other plaintiffs had a right to these commissions. And two, yes, going to the federal courts was the proper place for them to go since it dealt with the federal government, the central government they called at the time. But where things got interesting were question number 3. See, what Mr. Marbury asked for was called a writ of mandamus. Now, a writ of mandamus is a legal term. It's an order from a court to an inferior government official, ordering the government official to properly fulfill their official duties or to correct an abuse. This is from, again, Weck's Legal Dictionary. This also comes from the Cornell Law School. And it basically says it's the court issuing this an order saying, okay, Mr. Madison, you have to deliver these commissions. Now, courts order these things, they issue these orders all the time. What's the big deal? Well, if you notice something in the definition, see, it's an order from a court to an inferior government official. That brings up an interesting question right off the bat. But that isn't actually the question that was answered. That was a question that I brought up going, well, wait a second. Is the Secretary of State inferior to the courts? That's another step for another day. But what caught Chief Justice Marshall's attention was the legislation. See, yes, the Supreme Court is created by the Constitution, but there was legislation that basically determined how big the court was and what were their powers. There's a lot of information, and that was done by legislation that included the power to issue writs of mandamus. And there is a problem with that. See, Article 3, Section 2, Clause 2 says that all cases affecting ambassadors and other public ministers and councils and those in which the state shall be party, the Supreme Court shall have original jurisdiction. In all of the cases before mentioned, the Supreme Court shall have appellate jurisdiction. So one question was, okay, was this right to go directly to the Supreme Court? And there was a discussion in there. But the important part was Chief Justice Marshall looked at the legislation and made a very interesting point. See, to enable this court to issue a mandamus, it must be shown to be an exercise of appellate jurisdiction or to be necessary to enable them to exercise appellate jurisdiction. Now, I was kind of confused, and I still am, about why he was worried about appellate jurisdiction, since the Secretary of State, who's the defendant, is a public officer. Right? He is a public minister. He's a counsel. He's an officer of the government. So I would think primary jurisdiction, original jurisdiction, would automatically go to the Supreme Court. But it got to an interesting point. In order for the court to issue a mandamus, it must be shown as an exercise of their jurisdiction or be necessary to enable them to exercise this jurisdiction. Okay, stay with me. Where there's still some more legal stuff, but it does get kind of cool. So we get to this idea. Okay, does Congress have the power to give the court the power to issue these writs of mandamus? In fact, an order to another government official. That's really where this question came from. Can Congress authorize this to happen? Now, an interesting argument came up. You see, in the opinion we read, it has been insisted, and by the way, there's a link to the opinion in the show notes, so you can follow that as well. It has been insisted at the bar, meaning a lawyer actually brought this forward in oral argument, that as the original grant of jurisdiction to the Supreme and inferior courts is general, and the clause assigning original jurisdiction to the Supreme Court contains no negative or restrictive words, the power remains to the legislature to assign original jurisdiction to that court in other cases than those specified in the article which has been recited, provided those cases belong to the judicial power of the United States. I know, legalese. Here's the important question. Can Congress do anything as long as the Constitution does not forbid it? Now, if you talk to a lot of congressmen today, excuse me, if you talk to a lot of congressmen today, they'll say, well, if Congress passes it, it's the law, people have to do it. Well, that's a very interesting question. Can Congress pass a law to create a power that didn't exist in the first place? It's called negative versus positive authority. See, the lawyer said, well, since the Constitution did not forbid Congress from issuing these jurisdiction to the Supreme Court, then they can do it. Rather than looking at saying, no, the Constitution says exactly what the jurisdiction of the Supreme Court is, and they're not allowed to violate it. Okay. Where are we here? Okay, now we get into all right, so the authority therefore given to the Supreme Court by the act of establishing the Judicial Courts of the United States to issue writs of mandamus to public officers appears not to be warranted by the Constitution and becomes necessary to inquire whether a jurisdiction so confirmed can be exercised. And this is where life gets interesting. See, Chief Justice Marshall is saying the authority that the Congress assumed to give the Supreme Court to issue writs of mandamus appears not to be in the Constitution. Ooh. So Congress wrote a law, the big surprise, and by the way, this is 1801, remember, Congress wrote a law that's unconstitutional. Big surprise. Not a huge surprise. But what's important here is if the Supreme Court was given such power, they would be superior to the legislative branch. In fact, they'd be superior to the executive branch. They'd be superior to every branch because the court could simply issue an order saying, no, you did this wrong, go do this. Congress passes a law. The president or some member of the executive branch fulfills his duty under the law, and the court could say, no, we don't like that law. We're issuing an order saying you can't do that. Or we're issuing an order that says you have to do this. See, this creates the oligarchy that we have today. This idea that the court can issue orders to other parts of the government is where a lot of our problems are today. So Mr. Marshall goes on. It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by ordinary means. Here's the question. Does the Constitution override what the legislature does, or does the legislature override what the Constitution says? Mr. Marshall goes on. Between these alternatives, there is no middle ground. The Constitution is either a superior paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts and, like other acts, is alterable when the legislature shall please to alter it. Certainly, all those who framed written constitutions contemplated them as forming a fundamental and paramount law of the nation, and consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. Folks, when I read this, I got excited because this is the type of stuff that we find here at the Constitution Study. Mr. Marshall puts it quite plainly. And in fact, if you read some of my later articles, I start quoting him much more often now that I know really what he said, not what I've been told by constitutional experts. So he's saying there's no middle ground. There's no hemming and hawing. Either the Constitution is paramount or the legislature is paramount. And it is certain that when our country was founded, the Constitution is paramount. No act of the legislature can change the Constitution. Any act of the legislature that is repugnant, that is a violation, that is against the clear writing of the Constitution is void, of no value, useless. Now, isn't that interesting? We've talked a little bit about, or I've seen talk lately about things like state marijuana laws. See, marijuana is still illegal at the federal level, but the Constitution doesn't give the federal government authority over plants or drugs. So it's repugnant to the Constitution. So technically, it's void. And the states are simply saying, yeah, okay, thank you, but no, that's not legit. We're not going to follow it. Similar ones are being talked about around things like gun control laws or immigration laws. It's very interesting when you start looking at it saying, well, wait a second, if Congress is limited by the Constitution, which was written by we the people, we'll get more into that later, then Congress is accountable to somebody. They're accountable to the people who wrote the Constitution. And if the courts were doing their job more often, this would be, you see this more often where they'd say, sorry, your justification of the Constitution just doesn't pass muster. You see, Article 6 declares that the Constitution is the supreme law of the land, and every judge in every state is bound to it. That includes the Supreme Court. And he also knows, he says, it cannot be changed by ordinary means. You can't write legislature that says something that changes the Constitution. That's why gun laws, federal gun laws, are inherently void. They're unconstitutional. You cannot write legislation that changes the language shall not be infringed. The right of the people to keep and bear arms shall not be infringed. Red flag laws, was it Marco Rubio's latest emergency protection law? They're illegal, and they should be void. Courts should ignore it because they're blatantly unconstitutional. And if the courts don't find against it, well, wouldn't that make America interesting if we actually followed the laws? And the idea that what Congress does is void, we're going to get into a little bit more as we go through. So let's look here. If an act of the legislature repugnant to the Constitution is void, does it, notwithstanding its invalidity, bind the courts and oblige them to give it effect? Or, in other words, though it be not law, does it constitute a rule as operative as if it was a law? This would be to overthrow, in fact, what was established in theory. It would seem, at first view, an absurdity too gross to be insisted upon. It shall, however, receive a more attentive consideration. So here's the question. This is what Chief Justice Marshall is asking. If a legislature writes a law that's repugnant to the Constitution and is therefore void, is the court still bound to this law? And he looks at it and says, this basically just turns everything upside down, turns the whole thing over on its head to say that what the legislature does is superior to the Constitution. But just to be fair, he goes through and gives it a more detailed review, more detailed consideration. And you can read that. Again, follow the link for the Marbury versus Madison opinion in the show notes. They'll come up when I post this. You'll find out more. And again, it's legalese. I don't know about you, but to me, it's not terribly fun to read, but there's some very interesting information. So let's go back to, so let's bring this to this idea of judicial review, right? Whenever I hear somebody talk about judicial review, this is what I think they're talking about. Because Chief Justice Marshall said, it is emphatically the province and duty of the Judicial Department to say what the law is. This is the basis of judicial review. This is where things go to the Supreme Court, and we find out that a tax is not a fine is not a tax in the law, but it really is a tax because that's what the Supreme Court says. Or, killing a human being is not really killing because there's this other consideration and really comes down to, they look at it and say, well, the Supreme Court gets to decide. That's why, legislation gets passed and everybody waits breathlessly to see what the Supreme Court's going to say about it. We've turned them into an oligarchy. We've given them the authority to overrule, to veto legislation, just like the King in England did. One of the reasons, if you go to read the Declaration of Independence, we all talk about taxation without representation. Look at the reasons. Look at the 27 reasons we separated from Great Britain. One of them has to be with, the king would veto legislation most important and most manly to the running of the country, and he would simply veto it. Well, that's where we're at now. We can write legislation, but we all wait breathlessly to see what the court's going to do because we all act like the court is supreme and they get to overturn everything. But you know what's really, really interesting? Let's take a look at what Justice Marshall, actually wrote. It is emphatically the province and duty of the Judicial Department to say what the law is. Those who apply the rule to particular cases must, of necessity, expound and interpret the rule. If two laws conflict with each other, the courts must decide on the operation of each. In other words, it is the duty of the Judicial Department to review a law. They must know what the law is. They must be able to say what the law is. They must expound and interpret the law, not create the law, not simply say what it is in a vacuum, but to interpret the law. And when there are two laws in conflict, they must decide how they're going to apply those laws, how they're going to operate. They're going to interpret those two laws. Continuing on. So if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that case conformably to the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law, the court must determine which of these conflicting rules governs the case. This is the very essence of judicial duty. Notice how that differs from what we see today. He says, listen, if they've got a case before them, and in that particular case, there's a law and there's the Constitution and they're in conflict. He says, it is the duty of the Judicial Department to look at those two and determine how to handle those conflicting cases, those conflicting legal applications. That's their purpose. Right? If then, continuing on, the courts are to regard the Constitution and the Constitution is superior to any act of the legislature, the Constitution and not such ordinary act must govern the case to which they both apply. Notice the limitations. This is dealing with the case before the court. This is not a blanket no, this law is unconstitutional. This is a look at the court. The court says, okay, I have a law, I have the Constitution. The law is repugnant to the Constitution. It must therefore be void. I must place the Constitution before that. Therefore, they have to find in their case, that particular case, with those particular plaintiffs and that particular situation, that the law is void, and they have to find that the Constitution rules. Very specific to a specific case, not we sit on high and we deem this to be an unconstitutional law, therefore it is null and void. Do you know something very interesting? Roe v. Wade is not law. Oh yeah, and homosexual marriage is not law. Those are Supreme Court opinions. By the way, those of you who remember the Kelo case, the Connecticut woman who had her property stolen by the city of New London and given to, or supposed to be given to, a private corporation. Yeah, the Supreme Court got it wrong. Doesn't make it law. Just means they made a wrong opinion. They're human. It happens. But if you stop and think and say, well, wait a second, if Roe v. Law is not settled law, no, it's not the law of the land. It's an opinion of the court. If all of these Supreme Court opinions that are unconstitutional, but wait a second, those are applied, even if we take those opinions apply to that case and that case only. Now, if a law is truly unconstitutional, then courts should repeatedly find that it is void because it's unconstitutional. So when they bring a red flag law, which is a violation of your right to due process, your right to be secured, your property, to require valid warrants, to not have your property taken without due process, violates all of that. So let's say a case goes to the Supreme Court, to any court, and the court says, no, you know what? Sorry, red flag laws are fine. That applies to one and only one case, which means it should be challenged in other courts. Say, no, look, it says right here, the Constitution says this is a violation of that. How can you miss it? That's the part I always love. How can they miss it? But they do. So I'm sitting here thinking I've been told for years and years that, well, Marbury versus Madison says the court gets to decide. No. Marbury versus Madison says the court gets to apply the Constitution over and above the law. So, does this mean that the court reigns supreme? You may notice that, while in the quotes, Supreme Court or S and C are both capitalized. When I refer to the Supreme Court, I use a lowercase s because it's an adjective, not a noun. But that's my little thing. So here's the big question. Can the court overrule the legislature? Did Marshall establish this idea that they can simply declare a law unconstitutional rather than issue an opinion finding that in that situation the law is unconstitutional and therefore cannot be applied in this situation? See, go back to what Chief Justice Marshall wrote. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void and that courts, as well as other departments, are bound by that instrument. The rule must be discharged. In other words, it's not the question of what the court finds. The Constitution is supreme. If a law is written that is repugnant to the Constitution, it's not only the courts, but other departments are bound by the Constitution. That's Article 6. They are bound by the Constitution. The rule must be discharged. They cannot issue an order. In other words, the Supreme Court, even though Mr. Marbury it was rightfully his, the commission was rightfully his, that he had a right to sue, the Supreme Court says we have no authority to issue a writ of mandamus because the law that created that is unconstitutional. Therefore, we're right. Mr. Marbury should have this given to him, but we cannot issue that order. Wow. Compare that to what we see federal courts doing today, where they are issuing orders to the president or to other departments. They're issuing restraining orders and all sorts of orders. But Madison said, wait a second, there is no authority in the Constitution for the courts to do this or for Congress to give them that authority. Does it look a little different in your eyes? Do you look at your government a little differently now when you realize that, wait a second, if the courts really aren't supposed to be doing this, why do we let them? You see, Mr. Marshall recognized that the courts have no authority to order the Secretary of State. They don't have the authority to issue that order. Now, picture that today when we have federal judges issuing blanket orders, not just orders for their individual cases, not even for their own jurisdictions, but blanket across the United States. We're going to issue an injunction, a restraining order against all the United States. Where? They have no authority to do that. But we all act like they do. The court has no authority over any branch of the other branch of the federal government. They have no authority over the president, over the executive branch, over the legislative branch. They don't. But we've been taught, and our lawyers have been taught, and our judges have been taught that, oh yeah, Marbury versus Madison says the Supreme Court can review any law and simply declare it unconstitutional. But it doesn't. I wonder how many of the people that are saying Marbury versus Madison established judicial review have actually read the opinion of Marbury versus Madison. And if they've read it, have they did it justice? Look and say, this is what it says. That's why I'm putting the link in the follow-up in the post that'll follow this up so that you can go check it out yourself. Don't believe me, read it. And if you think I'm wrong, by all means, put it in the comments. Let us know. But if I look at the reading of what's actually there, this gives you, it becomes very interesting. Now, you may be thinking, well, Paul, okay, you're kind of pulling this out of midair. I mean, I actually haven't read that. And, maybe Marbury versus Madison doesn't establish judicial review. But where did Chief Justice Marshall get this idea? That's a very good point. See, very often courts seem to pull ideas out of their collective somewhere. So, where? Well, let's take a look. You see, Marshall was actually referring to Alexander Hamilton in Federalist 78. Now, hang on, this is a little long, but there's a lot of good stuff in here. A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has a superior obligation and validity ought, of course, to be preferred, or, in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. So, just as Marshall was saying, if the Constitution and legislation are in conflict, the Constitution must win. But look at how Hamilton puts it. The Constitution must be preferred to the statute. The intentions of the people. Remember, the Constitution starts out with the words, we the people. Yes, states form the compact. We the people form the states. We control the states. We're supposed to. So we the people are the ones that form the Constitution. The states form the compact, but we the people form the Constitution. And our representatives are our agents. Congress is our agents. So the intentions of the people as recorded in the Constitution is superior to that of the legislature. So the next time you read a piece of legislation and they put that little line in there that says, where is the justification? And they throw in Article 1, Section 8, you crumple it up, you throw it back in the legislature's face, said, baloney. Give me verse, give me section and clause. Where do you have this power? Because just because you intend it doesn't make it legitimate. Continuing on with Mr. Alexander, nor does this conclusion by any means suppose a superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both. And that, where the will of the legislature declared in its statutes stands in opposition to that of the people, declared in the Constitution, the judges ought to be governed by the latter rather than the former. They ought to regulate their decision by the fundamental laws rather than by those which are not fundamental. He is not saying that a judge should simply declare a law unconstitutional and therefore it disappears. He says, no. A judge's job is to look at these, and when they're in opposition, hold the will of the people as declared in the Constitution superior to what's done by legislature. This is a whole different idea than what we think of today as judicial review. It again, when I read this, I'm glad I went and read it because it turned this whole thing upside down for me. Continuing, whenever a particular statute contravenes the Constitution, it will be the duty of the judicial tribunals to adhere to the latter and disregard the former. Not, again, I'm going to pound this in because this is what we've been taught. Not to declare a law, simply declare a law unconstitutional, but to say, I have two laws in conflict, I must uphold the Constitution. A judge should look at the Constitution and a gun control law and say, they're in conflict. The Constitution must win. The Constitution says the right of the people to keep and bear arms shall not be infringed. Gone. I cannot rule in favor of the gun law because the Constitution is superior. I cannot rule in favor of the pick on red flag law. Pick another law. Anything that's blatantly unconstitutional. Civil asset forfeiture. Any civil asset forfeiture case, you should look at it going, well, I got civil asset forfeiture, but I have this due process clauses in the Constitution. The Constitution must win. If you did not go through due process the state did not go through due process to seize the property of a citizen, the state has to give it back because the Constitution says you will not be deprived of property without due process. No due process. No confiscation of property. Property goes back. Case closed. They can write all the civil asset forfeiture laws they want. If our courts were doing their job, they would look at them and say, sorry, guys. But they don't. See, contrary to current jurisprudence, SCOTUS cannot overrule Congress. They can't. Let me repeat that. The Supreme Court, nor any federal court, cannot overrule Congress. Don't believe me? Let's finish the rest of Mr. Hamilton. Whoever alternatively considers the different departments of power must perceive that in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in a capacity to annoy or injure them. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse. No direction either of the strength or of the will of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend on the aid of the executive arm, even for the efficacy of its judgments. Wow. I am waiting. And, there's a lot I don't like about President Trump. I like a lot of things that he does. I don't like a lot of things that he does. I don't like the way he does certain things. But I think he may be the first guy in a long time that could look at the Supreme Court or look at any federal court and say, sorry, you have neither force nor will. I appreciate your opinion, but you're wrong. I'm waiting for it because that's the way the system was designed. The courts have neither force nor will. A court has no way to enforce its opinion. In fact, the only way the courts can force anything to be done is with the U.S. Marshals, which work for the president. They're part of the executive branch, not the judicial branch. The courts have no recourse, no way to enforce their own opinion. They must let the other branches do it for them. The courts do not have the authority to effectively veto the other branches of government. And until our lawyers and our legislatures and our judges actually learn the Constitution, not what somebody said about the Constitution, we will continue down this oligarchic road of whatever the court wants, the court gets. So I don't know. I found that very interesting. Like I said, I love when I dig into something and I read the details and I find either it isn't quite what I thought or it was something a little different. I don't know. Tell me, what do you think? Head into the comments here. Where are my comments? See if I can find some comments. See what you guys are thinking about this. Where we go here? Hang on a second. I'm having a slight problem with my technology here. So again, if you have any questions, post them in the comments of the video. If you have anything you'd like me to cover, comments, place them there as well. You can head over to the website, constitutionstudy.com, and find out more. Doesn't seem like there are any questions. I got this is very good. Thank you. I appreciate that, Michael. Not seeing much more as far as comments. I don't know. Maybe the day change got everybody out of sync. I don't seem to have a huge amount of viewers here. There's only a few of us. So, hey, this is an opportunity. If you have something you want to talk about that's not related to Marbury versus Madison, now would be a good time to do that. Tell me what you think. Head over to the, drop it in the comments section. While you're doing that, let me see if I can bring up something here. Yeah, okay. If I don't have any comments, if I don't have any questions, then maybe some will come up. Again, I apologize for the issue with I don't know what was going on with Facebook yesterday. I tried for like 45 minutes to get on, and it just wouldn't let me. And apparently, other people were having a problem as well. So I guess we'll wrap up early today. As always, you can head over to the website. You can ask questions on Facebook. I try to answer all the comments there. You can also head over to constitutionstudy.com. I've got a bunch of articles and I've got recordings of the videos and whatnot there. And if you have any suggestions, anything you would like me to cover, I had somebody ask me about something that may end up being the April topic, and that is the national popular vote. So if you find that interesting, head over to the website, head over to Facebook. If you're watching this recorded on YouTube, comment there and let me know. I think that's what going to be my topic for next month. Hopefully Facebook working. It'll be the second Wednesday at 6 Central Time, 7 p.m. Eastern Time. And as I don't see anything else, I'll wish you all a good night. I'll wish you all a wonderful, wonderful weekend coming up. And most of all, I hope you will continue to read and study the Constitution. Hopefully you saw that maybe what you've been told isn't entirely accurate, and it's worth finding out for yourself. If you want some help, come and ask. That's kind of what I do. You'll note, like as I brought up at the beginning, talking about some of the conferences I'm going to, is engaging with people to help them read and study. So have a great time, and I hope to see you again the next time we get together on the Constitution study. Have a great night, everyone.
There's one thing you have to know wherever you make your stand. Came from a long through line